Queen Mackerel, EcoBank Ghana, Blue Star Lotto, Santike, Syntex Tank, PowerJet Batteries, Translight Solar, Franco Trading Enterprise, Millennium Insurance, and Atabia Herbal. And you're going to buy my Ekosiisen Ebremo. Honorable Akwaba net saying,
Ira Obi,
Bibi Aboko,
Yanko Pandom, now so
Adumia. Enti out of government at the saying is also I won't call ages department view.
There be Obi, semi Ofi, Akunta Neja, Miss Somnica, and no one is semi hen, so I break. Where me kwa bemu nem say to da no na no chere no se dey me yashim.
It's true. Now go back to the classroom and
me was say me wo classroom I go back to classroom and me chair dey wo gempa say na munim no me chair masters program ni CCR.
Oh okay. Okay, that's nice. That's nice. Wow. And for more amunim before so be Attorney General, deputy or a lecturer. So me Gimpa Law School.
No Gimpa Law CCR me my core school of governance. SPSG patcha when I say I transfer me.
Oh okay.
So me mfa medium kudi wa be mo fa me boa governance school ntine. Ye de me free governance school ne kakra. Me say akoba.
That's very important. It my yamra the substantive issue and say be nya time you didn't come about some other national issues, but first on the processes I say underway to, as it were, remove the Chief Justice. Government communicators, like I said, the president are maintaining fidelity to the Constitution. Onye Bonibia said Article 146 Ekano will follow to the letter. I didn't also be an issue with processor Ekosiisen.
Yo, me da CP mirror. Say me ka medical adawase pa achia wetiefo nyina. Ya me de se menya sa akwanya we so na. O platform ye mfa ni ago ntino se me so ma betena ha na che se ya akwanya kese pa odi ama me. Na mesrew se ne no ma me mre pa na nsem no ye mfa no ye mo no aposo na ye nchechire mu.
Very well.
Ebi akase o me ko baabi na me ko kase ya me peke me choose de me paint na wa hwe ma ma adwen se so oba me mra ye be ko ni nyina mu one by one.
That's fine.
Akusi.
That's fine.
Na se ne o kan me ye chechire ni na me saye lawyer na de ye me dene se ye benya sa akwanya we na ye di nkomo na ye nya adesua bi afri nkomo nim na nkomo no se bi enya nkomo tra a ya so ne hwene ana ya so baabi ni anso ni nyina ni anhwe mu no ansa me ko seminar we bisamene so no ese ye din sembi to akwen ma yenya obroni be se background to our democracy aye wo mu na eno ho no na mesrese Ghana for de be kwa adwendwene mu sa nkomo ya ye bedi se wo hwe ye democracy ye ka bi ma menka bi amamu na ye wo bibi enyina so miensa pa ni gina so broni be se the three arms of government na sa nyina so miensen biade ho eno mo na omo kuram eginam emasa ka bi ma menka bu ma mo no ekoso na ebiade ne ho so ebia so echeke ne ho ne ho ye fa bibi separation of powers but then there are checks by each of them nto mo nyina ade wo ho de edikan ye wo ye friend of the executive ye ra ye mampanyi ene da no ene ye wo mrahye bedwa so ewo ho ena ye ra speaker ene da no ene ye wo atemuafo ye broni beka say the judiciary ye ra ana obi obeba panyi odaso ye friend chief justice so wo hwa obi enen komo na ye bedie no enye say obi ana ye asona badapa enye personality sa nkomo ka bi ma menka bi amu eye offices no sa institutions we ne deka enti se bi se nkomo ne yese mempe the justice to konu asma na mempe sa judge you asem enye ho nkomo ne yedi odi ne sa na se bi nkomo no wa ni yi. It is not about personalities but the institutions which are the tenets of our democracy and which you and I must protect. Na ya am shehie ehu ensema kokoso ne se bi dwurum ye pese ye di judiciary no. Akwa me immediately make nyina se sa pona ebo ba astatempo be free last year kwa ebo boko no se Ghana fo nyina ya antene ho amfe ye se ankyere abɛnyam yɛn ho sɛ deɛ ɛkokɔ so ne ani nye ho a kwa me wokɔ court a yɛni NDC case ne yɛwɔ MPP case so me mayɛ MPP for case da mayɛ NDC for case mayɛ case bia enti yɛanhwɛ asɛm no ne yɛamfe yɛse anka ɛyɛ wo obi enemy any Ghana fo nyina na ho sonsanso no ebeba na sa adwurum no ho impact ne kuo bi keke na attack you say bi nye PNC fo nkwa na ebe ha wo mo ebe ha obia wo Ghana man anything sa wo kase a process eno manpanyi afaso nti wonye eboni bi a me ne wonya adwene na me be cheche sansense me sa process na onam so no se constitution na NDC for no kasa omonam so no na constitution na so within the whole year asama method ekwan a wo be fa so a wo de be ye niam nti sa wo ka se ontimi ntombra na if is wo di constitution enye no kre if se sa constitution na so one ni so pepepe a otimi tomra na ye share article 146 na eye on ekwan a wo fa so a utimi edekwadu ebo ye justice ye from justices of the Superior Court, High Court, Court of Appeal, ni Supreme Court, any chief justice ye war in way provisions be as a faso. And what kase dear me disep me kase o man penny wa form constitution and on a me betcha. Okay. So we shall also be the quadru ebe bo a chief justice. Was set and maybe no now here constitution pana not gap kakra wo and yes sound common and bedu sound common see and change your constitution ya hon sound common na ye mijina so kese and na case because Supreme Court your friend Ejechum versus Attorney so we are away eja watie fonti na me pensem no bia hu se bi enye se eye ebufuo so ana se eye emotions na dey ka asem na mom se nyina ye yie nti no and Ejechum ka se wo hwa article 146 na unlike other justices of the Superior Court na a chese obi de kwadu bebo mo a yes chief justice etimi find the friend is prima facie case say enyina so bi wom se ampa ese ye kwa asemi no ebi ni chief justice de no na yenyi ni se sa omo ye constitution ma na eye omo pese sa ne beba if se wo hwemu pa chief justice ndi edi kan ono so ye justice of the Superior Court na sebio ono ana fefo justice of the Superior Court impo ye find prima facie case na ono a sebi oda omo ano energy twum no e kire ye nyina na eja ye nyina ye di so se ese won so eno mo ka se ese president the Council of State ye run en munyam for mugu Council of State any president e find this prima facie case no na sa prima facie case no ena constitution no clause 10 of says a president finally said there's a prima facie case or best said the committee amo ma hwemu asem no na omo hwe kwadu ni mu so a owo ho kwan say or best suspend the chief justice and or be twena asem say adwuma no fasi ho atwen ansam ye hwem e ho no na me kire obi asese wo ka se sa tumi na ye de ahye omampanyin sa no obi antimi question a wo ye wrong na no me be kirekire mu ho wo hwe me na enye nhye chese obetimi na constitution na wo hwe provisions bi te article 296 any bibi te article 23 any impose Supreme Court cases or may decide say they said to me bi sa mawa eyesa wo yidi ne tene obi be say fair and candid it should not be based on prejudice against the person in other words it is subject to review it is subject to constitutional check. And it's how can it trust on the word processes intimate, why exercises our power and it's going to mean challenge. I mean, if it's the exercise of that discretionary power in itself is subject to constitution. If you look at Article 296, it's very clear on that. Nona yakase, then you say what exercises our power no. And two things. Se bi upesa wo ye transparent enough do na aka na me no mo ye adwene so se wo find this prima facie case na se nka ma ye reasons ma ye di
manfo ni reasons
ma ye hu reasons wo de find this prima facie case wa ma eno nya hwe but without even the reasons which I believe are grave in impo no it is still subject the fact that discretion can be subjected to constitutional review in itself still stands. Na government communication for say minim ekwanse no so say megina so akatia e de bi de beto wo Facebook platform so eliki ye and you say, ah, to channel Bisasenti President, a quan bear so, while my information wants so Cratan or the Comma Chief Justice, while my reasons be a then you year or a quan bear so. I mean, Obi, Sebi is only fair, so will quite to be declared to be Bobinas will me one. That's how to me children of quite crowd, Jina, so we are so quite doing in a soon tina, Brabe you one. And now, reasons now, ma, name me say, reasonable manner or her sa petition. So what man now would take president and name one, yeah, petition in her say, Senkabe find the prima facie case. Now, face what's suspended because suspension, no, and this will find the prima facie case, no, now, what is our committee, no? No, quite do na yemiensa. And then make Yamrema me paths, and then Miss Yamrema, Yam fast, I'm not posting up.
Your time,
but
even on some other competition, again for this now, Casa 14610, no, Ekase May. In the May, nature say discretionary power.
No crane.
And on penny exercise. So, bit Macasa May, or bit Macasa May. Good. And sir. May no just in relation to suspend or not to suspend the Chief Justice. No, because for other justices of the Superior Court, there's a provision be anyhow. Good.
So what you say? I come as some number. A home po anyhow.
Yes, and anyhow.
Yes.
Just with the Chief Justice. And I will say, so we far 14610 nenkwa. Now one share other provisions in the Constitution. Now we mistake. No, into the Article 296 by. 296 no eka dainty na ofri say president can follow into why mistake
you me that's obi mesro yenko article 296 no ho na wo hwe 296 na with the miscellaneous chapter of our constitution wo hwe o say yes mami exercise of discretionary power that is the heading into the president exercising a discretion. Wow, cast 1 year bonne may catch us will bet me a bonnet. Say any article 296 we bra if so say exercise of discretionary power. Now say why in this constitution or in any other law discretionary power is vested in any person or authority, including the president, that discretionary power shall be deemed to imply a duty to be fair and candid. In the exercise of the discretionary power shall not be arbitrary, shall not be capricious or biased, whether by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. And C, it says that where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this constitution. Now, see, you know, and yet, Makase, SNK publish it, see, because you paying for me a constitution, and such as say, and this says a provision or exercises are discretion, a bay arbitrary. So, we guidelines be constitution by constitutional instrument, and say, and we say, yes, Messi, quite say, the facility includes the exercise of that power under that article 146. Yenisa, constitutional instrument, and assembly so swaba. Now, she ain't me to and Korean cases, now, I believe said the guidance can even be sought in a number of cases and even this position. Sebi, and some kaye be a year roman penny, eke kaye. Impo brown yiminyame ye manpenny, any brobe manpenny, ye and penny phobia when DC kunim, and some more kanya chese a ye trimu pobia ya bosse, sa a buying sap back where ye judiciary no, ye be interfere. Na usho kabi mamin kabua mamin was say judicial independence a ye very key. And you say ye do judges mu and I say ye into ye be what aquam where a tresse ye ni esa judges ho. Obi de bia mesre kaze Ghana for mesro na yen twi sasem pa nkwa akiri every say hu ni be hye ye judges mu say hu ni bia na nka emre bi etwa mu no e be hye judge mama ye besi na ye di matters de ye di kunkum ye judges if so mo ka say da bi efen wo mo se kire ekobi ka say da bi yempene ma mo nyesa eno ebi na ene democratic state 2025 ye hu bi no eno de enye kuo eno kwa ne ma ne ya asefem kese no se we de enye kuo obi ma me ntwe wa adwene si asem bi so ne enko ya bako sem kaka se ku mposia executive arm na me kan ho asem no e fole legislature e fole judiciary pe ene da so gina ho ma me sanche wa adwene kwa asem bi so se yeto abawie na ye de o mampanyin foforo besi so ana se me fa se party kro na mampanyin na se de yes 6 January na executive ne fole legislature ne fole eye judiciary pen ya agina ho eno nti na chief justice na beden esa start sa process ni bio enti se bi wenye aban ekuo bi ase yetoto o masene enti mesra mi ko me tinsam bi se ne ase na se yade bi ye waden ya mesre sebi nsa we kra anyepe satien kra anyepe yemfa ni de ma de ni de wo no na we kra de me si ehun sunsanso no ebeka obia bi enti mesre na yenko back to article 10 no
yeah but you are saying sir because of 296C no I can say so be exercise discretionary power na nipa na judge and any other judicial officer it was say publish it through a CI and I say any regulation I be guide us our exercise no and because in this hard any binti and I work as that exercise of discretionary power under 14610 no ebia no mampanyin atomra ewo that's your argument
enye no nko a me say she A no any B ni C no A no or say you shall be fair and candid B no it shall not be arbitrary and based on prejudice and I'm C no enam ye mpanimfo nyanso mo hu say be ya ye be dis discretionary power no so alma obi hu say ye betimi a challenge it guidelines say the challenge wo ya hu ni and C no but C ni ni name we can have guidance from even A and B o shan some kaya every end realm manpanyi o meye o manpanyi wo keka and judges no politics MPP politics and the make sense I show prejudice no I show bias I show set trimupona ene ehun sunsanso ye hu a ekosui eno na me say oka ye yan kasenti pi but sebi se asam eba ye hu ni free akire na se ne ekokoko akire bibia che se eye tirimupo bi na ekoso a mesre ganafo se mom ye ntena ho ne ye nsori waka efi se judiciary na efri mpempen so efri kumre aboye ho ba abesis omo ye perfect me nkaso omo ye perfect omo ye perfect aboye ho ba ma sebi omo timi fi omo se kire executive ni other arms no si amo omo ho ban ne ye mitwa sa asayi to ho na ban bi e beba this asa ne so aminu mienu na ehuna mane
me wananka me bebusa se but for your intervention on A and B, you know, can be with the C, you know, say the Ransford France case no comes into it, and that about enya two positions. One was if we expect say for the exercise of every discretionary power, no, it was a C and as a regulation be bar. It might lead to a meltdown in governance. Oh yeah, and now no assign car say. But say a basse who engage in any quasi judicial act there, then you need some regulations. In the almost had two way in the case. Obia Jina in the ABS as a president so okay. It cannot be expected except for the exercise of every discretionary power. It will see in a CI. It is a when CI be anywhere I mean Tom Rebia. That position can be taken.
It cannot, and I'll show you why. Because Obi, we share 296. It doesn't say each one of them. It said A, B, and C. It won't mean fine about whether it's not quasi judicial all three of them together. Enti emposi enya ya enkyere se eni bi no ye to twene nchen enti nsem kaye na aboba ba mprepia ye ntimi ye se bia me ani ana ho anti amfe ye se ankasa de mode kokoko ne de ye mpene so na ebe ha ye ka bi mami akabom eno na ene de abedru ne na susu ampa se ye kasa keke if you say prima facie case no be ye no ejina petitions ne so
yes
yanko petitions ni so na yen said the reasonable man embrem ye can be said the reasonable man say me no mi enu si ye hwe petition na odi ye say me wonyina so nti ye hwem no wo ye de sa petition to am ma wo be find this prima facie yen ko de edikan petition no
and prima facie say ye share petition him on the face of it no CJ e won seme wo so ba be yi ano. That's the prime.
And a petition will nyina so. Yes. I was saying. Esi ye to aso ni ye kohwehwe mu mo.
Very well.
So that is why file case bi wo court na esi afa ye komu pa bi en pensemu bisa questions wo kana wo ye bisa esi ye sa adu ye fa say kwan so. Na de edi kan ye say ekuo bi de shining stars. Obi. Na omo kwa edu ni nyina gina niema mienu so. And now we say baako, we say and now our constitution now say there are 3 grounds. I'll bet media abetia Justice of the Superior Court and his Chief Justice. And they say there was a stated misbehavior.
Yes.
And
incompetence
were him adwuma ni and asese bi na adwene mu ne body no yare bia ba mu anum ti no ntimi nya na adwuma enti shining star for no government presidents officials omon condemn me wo mo no mo de buy me nyina ye hu bi no the edi comes stated misbehavior na omo de kwadu abo ye maame Chief Justice enie omo si me bi etwa mu ye maame tro krata akoma o mampanyi na na adodan kwa akufu ado say mira mampanyi say adwuma na aba judges for Supreme Court adoso wo hwe your constitution ma and this is US Supreme Court anya case bia na omutie o Supreme Court yes a case be hanan a ombetie be emu oha yes ye de ne ni saa mrani buonti sebi obi atimi de na isem ebana ena adwuma na dɔɔso na manso na dɔɔso hwɛ kwanu nti na de mu bi de bi ebodaru se yenye edia yen promote edia bifika adwuma ne so enti mesrɛ o mampanyi sɛ wo badwene ho sɛ ye bebie ye number na ye wo Supreme Court no ni edi bia beka ho na sɛ wo dwene ho sɛ wo bebie mu sɛ ne me propose na enkrofo bi o mabo o mo ho modin o mudin ni a mehwɛ sɛ wo be consider obi eno ne maame ne bone na maame nche ose ne judges ya appoint wo mu okrom judge bia eno na ebi mu kasa judges ne partisan me say ne judge bia wo Ghana enne se misi supi say ne ono so ye partisan if he say judge bia ni ho a ya appointing was Ghana krom ha president bi ninsanim free lower judges na magistrates ni circuit court judges ni nyina no even those appointed by the chief but president as wo team so president kasa me mpe we ya untimi nya ho hwe ekwa akosi Supreme Court say wo ka ne saade a na ne judge bi o ekrom ha bia ye partisan eno na nchen wo se kwadu no wakotwero sa akrata nti yenyu na wo hwe ansa ne ba appointed judges wo impome mu ko bi a ye friend Ghana Bar Association wo ka ho wonim Ghana Bar Association planning prepare to me a recommendation ekokase o mampanyi FGD say judge wo bone homodin Judicial Council part of the process here they appointed judges nyema pise bi de bia ya mekase impo mampanyi yire nti susu ampa so mampanyi yire ne da wonti mekase mira mate say judge wo bone homodin ti ehwe na no ka na mra be no wato say recommend say be mpanimfo asofo ni ade ebi ko atimi kokko to hwese ne judge ni si eye na adwuma sa judge we de wo ya ade na se ye de konin entomra na emomunim uma sa recommendation it is mere recommendation
o mampanyi ne pa
enchichire o mampanyi opa na obefa opa wonfa etise bi me mpanimfo ye kukudamfo akohia o mampanyi ni akase o mampanyi ye sere ye bibi sei opa no beti openso obekasa maten so memfa na ye hwe ye no enye se o mampanyi mpo ofa sebi ofa krata ne ho didi dwuma efise besi ne ye sanko no ye appoint wo mo ye nye wo mo
but the other things they say the letter of the Constitution relative to appointment of justices it mentions the Judicial Council and the President and Ghana Bar Association and Chief Justice and any person be over baby or feel say as soon as you be about home into me minimum opinion in the home como a clear Judicial Council and the President and then the more also say no other party and there was our quiet cross say or be involved in that process just the Judicial Council and the President
obi me das enti chese say the come na kosi say wuntimi kra nkyere wa adwene say amamu onye nkoni say assuming say a Judicial Council enti ko kire na adwene kra so ka say no yem na obi atimi kire na adwene na no bone e wo mani sen efi say nya say wo kire na adwene na abam na ye automatic say bi eyenhye ema mampanyi say ese wodi so ana anya hu sunsanso ehun susande meka ne say wonya Judicial Council wonya GBA wonya owi na wo make proposal to panyi bia wa entomra asema mpese mijina so entomra if it's a recommendation GBA versus attorney general there are a number of cases even on the advice of in consultation with these are advice and the president is not bound
by them
enti entomra biara na obi susu ampa sese bi nkore ya omo wase anu omo ye adwume me ya de bi ni metimi adi omo ho adanse yi na wo a wo ne omo ye adwuma yi na betimi adi omo ho adanse
me
no kre ena entomra biara no enu nti so ka se enu nti watwro krata sebi Omampanyi betimi age na odi ahye ne draw we matom ada enunti me say ye di kan entiamra bia and na your constitution so it has to be evolving and I say ya mamu ni society and so entomra say metimi atwes obi me ba me hu se dwumadi amudi nka mu ye ni say ya nka beboa wo se da bi menye HR menye monitoring and evaluation director wa henti no meni hu kwan say me ye ya na matom renti no ye mfa kwa edu bi mu.
But there are also decided cases if any law in our country are a specific process on how things are to be done, you have to follow that process. Another lawyer, Professor Kweku Asare,
professor there.
Professor, law professor, professor of accounting.
Okay,
good.
It does.
Professor of accounting, but he's a lawyer. Or say, the argument I will propose back when I say, and where questions I will throw my Ghana Bar Association, or say, Supreme Court nominations. Does the GBA support the Chief Justice personally selecting and submitting 5 names for Supreme Court appointment, contrary to Article 1442 of the Constitution? Or say, nomination criteria. Would the GBA explain what criteria the Chief Justice used in choosing her 5 nominees and whether it meets constitutional standards of merit, transparency, and fairness? And also, usurpation of the Judicial Council's role. Does the GBA condone the Chief Justice bypassing the Judicial Council, the body constitutionally entrusted with recommending nominees to the President for the Supreme Court? And also, backroom deals on judicial appointment. Does the GBA support secret backroom exchanges and entanglements between the Chief Justice and the executive over who sits on Ghana's apex court? And these are questions are always I went ground to the point say the Constitution was specific on more to this argument. Chief Justice where that letter and you should backdoor breaching Article 1442 of the Constitution.
Kwame, we see that procedure o can be. The di kan ma me issue disclaimer be. Ahana me won me nkasa ma GB. Ghana Bar Association, but I'm happy say you bring this up and only disclaimer na person. To me me one member pe. The me can me masem GB for asem. Na the because that process must be followed. Now, President would these who appointees as justices no based on our recommendation yana.
As we speak, no. Good.
Entiantomra. That is the interpretation to be given to what you have said. And na or ye say Professor
Kweku
akano. Mesre na ye kaye di san komo ho ani beba but there ama menya a limitation ka kan so GBA nti mesra mo boso bio se me nkasa ma GBA no
but I
question our
GBA okay me GBA
to bring a different perspective. That is fine. That is we can accommodate them.
Replace you with GBA.
No, we can accommodate that. Yes. So entiantomra ena enye a year president ediswa into beka se nunti this won't no now our point is no one fa sa article 144
even say act na happen the mere intention to want to send sa letter no entomra
obi unim sese bi ye wa ban mu ukutimi hie bi ni pakra wo abonte was judge bi we bi asem kan minim judges ni nyina nti let's say bi me ibo bi ayi bi afin judge bi wo mankasim ha wo ya ade panti GBA amu na megya mo ye mpanifo ti ye bakasem ni nkomodi amomfa nto enti na yi ano se wato mre o efi se wo no enye wo na sa power na se wo se recommendation kwame ya nwene mu is absurd. Enti sabi enti kra sabi ye mpanifo a ye wo abem kaka enti mi fi ya so kra ntoto from e mo bi kra enti mi approaching catch say every say minimum kasim e bia ho wale ho kwa me practice or mo ho edi ho dance enti mi de basa oh we mu de ye me say da bi kwa no tum if say wo no article 1 for enya wo and also ma me say recommendation akwa me is absurd. Enti honey the first ground for shining stars for no na wasa akọ second one na hono na kwame eno de asefem pa kire say wo mo say kwadu ade bo ye maame chief justice ni nyina so ne say wotena cases bi so boya bo ye penny afenyoma ken case bi e ba say wo mo make orders bi ni ade kwame ho na eye se chirechire mu yi Chief Justice Chief Justice nyina no so wo mutena asem so a or 1 vote.
Yes.
they are not fewer than 5 judges of the Supreme Court. Ni vote ye ba kwame ye hunu bi pay including Chief Justice Tokonua. Other panel no decide say the wo kan ye no nya adwenti e beto atia a dissenting and why minority view. Now kwame me twa adwena sem ase nti say wo ka say case a wotena so di ye no wani anye ho a na enu nti wonno ye nyini fi makwame masem bisa me bisa on say na nine na ka ho mo ne tena case ne so na yi sebi kwame ye sa na ne yebu o manim ti ana meka asem bi a cho so wo hwe je tun case ni yi a eno so na e ti se CJ akwase yenyi ne sa e na ho asem ba Supreme Court na e se CJ na as part of an administrative function on panel judges and we decided oba panel no mo court na justice that bane Justice Wood ni so far din ramuni ade ne keka ho asama ba ko beka defendants ba ko beka nti wa pagya ne nsa wotia mu kyerɛ sɛ na sɛ kwadu am petition amedia be me betia CJ na eden ne ho asema ba CJ na na ɛsɛ be mpa no na justice that ba ka sembi na mesɛ Ghana fo nyina sɛ yɛnta wo ne anwini hu din wɔsɛ asɛm be na wo ne yɛ ken sɛ wo ka ne sa na sɛ bi wo bu yɛ nintia wo sɛ we are not malleable clay in the hands of the Chief Justice. We have our own independent thinking, different and distinct from the Chief Justice. And to say, "Kasasa sebi na ubu yenya wo nyina nim ti a kyerɛ sɛ sebi yenim ye nyansa." The Chief Justice bekane ye. Enti na ubu yenim ti a. Enu bi na shining star for ni yo. Enti judge bia oni CJ tena sa cases including afenwoma cases. Yebu o manim ti a sɛ sebi omo ye dolu. Sebi wo muntimi nwene ma wo mo ho na de ye ya won say for akogo ayam ganso petition wa kan sa asem ni abia wo say omo chain no contempt of court no CJ pen chain for contempt and what the publication bi ka ho say evidence wo koma sa ono an evidence not justice Prima so tiano Justice Kolendi so tiano said de wo ye no suban na wo dead wo court ano eye contempt ye ni Supreme Court in kasa nti sebi wo kan na wo bu sa judges ni nyina nim ti eye den na se Supreme Court tenase na omoma decision take collective decision a yetimi eyi baako eka say your no ni decision nti no yemfa so wenyi na sebi ene sebi just the Prima mu no omo tenetena akoge case nyina na ese yi omo nyina adi so what the sa interpretation e kodia ene me de me enye no kwa bi so wontimi fa nyi omo di kire say eye collective decision na me de ani nti a wabu sa judges no omo ni Justice Tokonu tena ho bi no eno na ye me ya na ye ma
ba eno no petitioner no any choice say yes mo ye justices 5 and mo tena case ne so I can elect, say, my petition may bar against one of the justices I tonight.
On what basis? Because she didn't take a decision. The court took a decision. The court, made up of not fewer than 5 justices, took the decision. Omo ye 5 into omo nyina ntimi nkasamum. Enti ye penny same possessi jeniwa the next senior on a presiding on such a panel. Enti will you be saying say senior be preside eye or no decision ana? And a records which says someone you take a decision unless about where dissent no. It is said and you dear course who case in more our macan or more petition. It is said CJ in a year, it is said Justice Prima in a year the same thing. It is said Justice Kolendi in a year the same thing, make can't go case. It is said you are more individual, I can't the same thing. And it is said who choose what. Not just I say your discs are quite doing be more macanina.
I get the drift, but let's assume say now to the substance of allegation. Say be a sole judge and an ethic case so. And a nipa no any how a decision the court say akologo die. And cobetima cite as our sole judge in the petition and Article 146
and no. And on 2 grounds, Article 127 said when the judge performs his function, it shall not be subject to litigation. And on Chilesa Krugu need other forum to address his grievance. Because even when he sits as a single justice, he sits as the Supreme Court.
Yes.
He doesn't sit as Judge A or Judge B or Judge C. And for usual, they use them for some of these applications, you know. He sits, so when you are citing a decision of the Supreme Court, quorum that single justice. It's that single justice. Kwame, sorry, Obi. And some are making you say, what is our Kogo say, Wabumanintia, or see, is even an affront to my dignity. Suswan pass empodia wokano, a baby woman. your human rights court wo ho so obetimi akoso if you say your rights have been dismissed na me bad and you for read no so say ye obi adi say ye wadia now if you say ye die na yi me no ani kwan paso a ye wo constitutional providing means and ways other laws provide say if you say your rights have been violated you can go to the High Court under Article 33 for vindication of your human rights. There are other forms who feel say ye medi na ye medi no enka ya you to me court and a court in why you be paying I'm ya reinstate you and I compensate you for and yet a ground for removal under Article 146. And the enemy comes in our business any or my own money and then or money. Na under Article 146. And yes, I need to your democracy.
But how about the arguments? The maker of the law no, will not use two different words meaning the same. Into the two different words, they are indeed two different words in form and substance. In stated misbehavior, now incompetence. Incompetence can only be about the work of the judge as an adjudicator. And it's a judge, Emma decision be. Not decision on the face of it to move a decision where yes, even though appellate system no, but decision ought to be a decision way dear. Just a way first year faculty student crowd who make his decision. No? Should we say because the appellate system no, and then you move up and appeal and now say judge na show incompetence I was see to me Edinburgh under 146.
Kwame, senka sa CIE by anke bebo am yin ye say. So we follow sa argument na nya wo no making me say nya na make amount for making we might as well discard our appellate system and other fora for addressing decisions. Obetimi examples ni say judge what na se na free BB expert communications. Na sabi wo didi sa ankomo agye sabi obi adwene na ade abedi sa dey incompetent. So it's incompetence. Na me sha mommy careful how you interpret things. Sabi trasa no. Then enti enunti enyenka dey wonim judges anke dey petition kwa edu bekosi yenyu omedi because wonim dey bia me ka say law adwuma na na manso twen no. Eye den abako ani beje bako ani nye. Yes. Plaintiff ni defendant, applicant and respondent, petitioner and respondent. Eye den obu asem na bako ani nye. Enti wono ani nye was incompetent inti meko. Any judges in yanka dey bia petition bebo etia wo mo. Enti mesra mo me entoto sa article 146 na ase. Na especially be am cause such an arm of government. Enti shining star for there no. Okay. Question is obi so mo say. Enti wo mo nyina ka asem kro. Oma no call benkro na ase yanunti anu yenyina so mfa yi chief justice na ne ennan na aka na se dem say se yi wo mo okay e honti na me say so wote ensam na se yie se be ka bi ma menkabu amemro te ase yie na ate constitution ase yie wotim say asem we die eni nyina so be from the start it was dead on arrival eni nyina so mpo even remotely eba na eni nyina so eye po bi keke eye for shining star yenko eno so argument here mama e bi ye for akogodi it has some discuss akogodi it's what the evidence
there is this second leg about court records and so on, or say what was in the record of proceedings, no, and shada entirely and reflected what happened in court on the day.
Good.
And no say against the right because if he decides to say the Awokano use the appellate route now, we hear proceedings of court proceedings now they are filing or appeal, no, and what is in the proceedings doesn't reflect what happened on the day. And he believes a grave injustice to him.
Yo, Obi, medase, and us menene nyadwene. Empo asemko. Unim say ye juma ye free BB rectification of records. Yes, so unim say. Yes. I say told out to me kwa pu na ye ma proceedings na ye high court na BB aye referee ma utimi apply to the courts. Yes. Na court no a order registrar. The entire medicine say me base enye judge in charge of searching the record ni ade. Na momo kase me ko bisa search ni ma utimi make application e ma judge or that registrar say registrar na in charge of those records or answer searches so enye chief justice enye judge bia enti say wo say wakoye search say ye no kre say enye no kre na no enye chief justice and a judge aso ye na esi make rectification of records e twe wadwuna si bibi so say Empose who se me records a medical appeal no bibi ni ma wotimi make application wo court.
Yes.
Emma court no order say registrar asema owura yi kan wo se ye bibi afrim enti me ma wo order na ye then as such an administrative work as yes me person cause as low as this ye this akwa edu ni bobo chief justice asebi na adwuma ni ade do so say ono na ye search enti say woni registrar nya ensa wo so bi na wo fu say bibi ni ma wotimi say aba court 5 of one na say mesra mo dan na mo chie me contempt mo nyina na mo ha record amanya ni enye the reflection of the year enye man panyin na ade kɔ ne ho de sa complaints we kɔ so man panyin na mehwehwɛ sa record and ni chief justice asuyɛ any man panyin so asuyɛ
registrar of the
court registrar of the court.
But the argument that because the chief justice sits as the administrator of the judiciary and once na president of that panel.
Okay.
Enti ebia behind the scenes na manipulation bi akoswama eyi sa ne na free.
And one thing I'm saying say when to me enyi adanse bi e kire say what follows our process to get the thing rectified. Untimi mo sa akwa edu no. You have not exhausted the procedure. And then preemptively, you come laying the blame squarely at the doorstep of the judges. And it's a mess. Me say, because I me abe addition. Ebe me who court system no say ni esi weke. And yes, I will yes search obi. When a sign search them out, yeah registrar.
The registrar.
One who say judge now tana ho. I would do assembly into quite search on why search mawada.
No.
It's at then ye this do no ebe chief justice. Simple high court for low near the no money search. At then ye expect to see CJ be in charge of search ni record near the nuntino. One ye simple mea. Mesa kosa court for him say record a menya ni nya asama esi ye no eno no. But kwame me enhwe hompo. Wo be boss akwadu me dey me say let's not lower the threshold of Article 146. And when I made the beba than you for reading and so. Uka ono ekwadu or the boy I am ganon yinano. Evidence by open or the can who you know law platform the
law platform report.
Sebi ain't men some tra ne no yenyan yina so edi abo obi te se chief justice kwedu. Obi emu eya na na asifem. Set Daniel Forridie when ya kukodra traw paragraph 5 and paragraph 6 of the petition say one of the asama watregu krata mu ne kwadu odi abo chief justice no enye mmre a ese wodi evidence bi aba no na one de wabo kwadu ne tra kwa me it is unfair and it me say to show the seriousness we give to the judiciary that petition in particular should have been discarded in limine at that point if someone fa adeno serious process no fa serious.
Evidence.
Yes, Kwame. If you are filing your application, you are calling exhibit. You say, as lawyers, you are chile moon pesem. You go can't your court and say, "Dear media beg, me for evidence in my just hearing before committee answer." Tinye wa exhibits aye dey attaches application ni asa akogina me chechim na the other side so question bi bisaye ya we bisaye am yenso ye yia no enti ono de ne de me say ono de ne kwa de eye worse because you don't take our democracy serious, you don't take the president
it's
and
also
other people
possible
serious
because how judiciary ni operate, you know, and the nature of the allegations are all making, you know, may be readily difficult to get evidence. Maybe a whistleblower be na a can't be trained. Only evidence because I remember say in the Loretta Lamte on also go through Article 146 say at the time Shraj boss. Mekai said petitioner and lawyers had to petition the president, said they would want the president to get the woman to step aside because omobe evidence bia as long as that's what area Juma as head of that institution no getting her evidence no ebeyedin the president agreed and normal woman step aside eventually committee ni finding a guilty man president yin and all of that inti that by that parity of reasoning no unyi ni say ebia Daniel Foria allegation based on hearsay. Now, as the process goes on, obetimi agada sa evidence. Now that especially CJ no ya suspending and now obetimi access to sa evidence in ya the back in the
Kwame, Obi, I'll tell you why enye no kre sabi asem na wakan sa assumption na wa making enye no kre no on two things. First of all, okaya ka case bi onu awom eno nso so oni copy. He's not taking the process seriously. Or mention here, let me go to the specific paragraph on the petition. Or kaya kasi a transfer judge be in one of the proceedings are onwaye involved. Until onwaye involved in so case na again. Some of these are public records.
Yes.
And nothing I am got try say oh yeah, but no any evidence na sa shooting the case no. Was this unilaterally caused my arrest? Then you go further down to the same exhibit. Then Justice Puaman, the publication it was there. It said any Colin Catcher said this is not how you behave to the court. Even if you want the court to agree with you, you operate within rules. You don't do that with violence. Yes. You don't do that with this lack of dignity. You don't do that in contempt.
Yes.
What yes? It's as someone can say no. Say CJ one when ya sa in some one on ya adiaboko edu 21 of them on you know. Ubi hebi abako was say in the case of Okujeto Black and Attorney General, then he lists some of those cases. And these are cases that are easily obtainable. Wa krana wo your party in one of them. Media me hu ni say a pobi a ya bo ato ho. En tentem so no say bi ni nyansa ye ne say ahitofel say ne Bible masem kan. En wo yes a mistake we nyina. Wa wo case a wa wo mkra went me amfa attach as evidence. Media search me sa secondly say umu yen process no something as grave and as serious as complying with Article 146. You boldly, pompously and arrogantly state in your paragraph 5 and 6 say, I am not required to show you any evidence. In other words, anybody, any Tom, Dick and Harry can just put pen to paper, make bare assertions or allegations, and we, such a democratic group of people, are supposed to take you serious on that. Absolutely no. The threshold should not be so low. The threshold should not be so denigrated to remove no person but the head of an arm of government, which is the judiciary, which is as independent as the executive and legislature, and which must have security of tenure.
Remember some of the other allegations are in the other petitions. No? Done it on the travels. Then
and no medical catcher say you see a taking it serious, but some can't and ye be kuku. So we feel some me for serious. Now me be class some chere trasa. Now fi some for serious na enu ntimi nyina so and find the Prima facie case and find suspect teachers. Obi na emu ya na ehu ema ye kebi mama.
Okay, inti meba me dealing with travels there because I don't know CJ response no you could infer and see some admissions were in there, but on all the allegations are waka, and for every lawyer will be you reading through the petitions, looking at the allegations, no, you think say okay, maybe a bit more should have been done on the allegations, but the Council of State made up of 31 Ghanaians, respected Ghanaians, high stature. Omunina go through some petitions, and we are told, say, out of the 31 of them, no, 30 voted and say yes.
30. You 30, confirmed?
Yes. 30 voted and said yes. Prima facie has been established. The only person on record I have to say or no recusing or say or abstaining, and the former Chief Justice, Sophia Akufo. And clearly, and on that Council of State, no. Former Supreme Court justices, also, you were former IGP, you were former Chief of Defense Staff, and a whole lot of, Ghanaians. I want to say, almost will go through. I can say no. See, there were questions to answer. Then really, maybe there are some questions to answer, no?
Obi, with all respect, that argument is made on assumption that they can get it wrong.
Okay.
But you agree that they can get it wrong. And it is my respectful view on this occasion, they did get it wrong. So we follow me. The Council of State is one institution I respect. You know why? Because my deceased father, may his soul rest in peace, was a member of the Council of State. Intimate to Tuamase. And I said, I'm casting Komoya about CJ removal and your personal.
Sure.
It's not about persons. It's not about whether you like this one or you don't like this one. It is on principles. It is on our constitution. Ejina ye mra yen ya yahyehyɛ ama ye ho no. Ene ye ka bi kuma mi akpapu ni ediko. If you make that argument, you proceed on wrongly on an assumption. Say, omu di omu ntimi enyen wrong. Court to kura say omu bu asem.
Sometimes.
We mo ye kwesai function of it in umpono. Let me get it wrong. Emma, maybe a higher court and a different court constituted now in a way. No, it in catch you said you're wrong, and it is my harmful, unrespectful submission that they got it wrong this time.
In establishing prima facie.
In establishing prima facie case, based on how I explain things very well.
Even on the issue of the travel, you think they got it wrong?
Again, yes, they did, and I will explain it. Again, I said we should treat Daniel Fori's petition with the contempt it deserves, because it openly, flagrantly, and with impunity says that I am not required to show you anything. In other words, I am okay, it is okay to find a prima facie case by me making bare assertion, including a decision which I purport to be a party in and which I didn't even attach for your attention. So you are not taking the petition seriously. And so the content of that petition should also be taken seriously. But what be some and I've seen some communication going around, say travel, and they said security should travel. And you should read the whole policy as a whole. But you should trace this first of all from Article 71, which then mandates the president to then set up an emolument committee, which determines the privileges. Or the conditions that means the privileges that are given to some of these officials, including the Chief Justice, which of course, like the legislature and executive, are no substantially different. Now, sir, when to share a justice policy, me makobis and menya copy wo. Ushasa travel policy now. It makes reference. It says reference one.
Yes.
The Professor Dubuando Committee, Emolument Committee, into a winner so a free baby. My response to that travel is that by law, practice, and policy, there was no infraction. Because the CJ for official travels there's unlimited official travels that he can make, which he is allowed to travel with his spouse or any other person. The protocol officer of the judicial service says a secretary or within the judicial or any other judge which he uses. But for the personal one, our protocol officer private one, he should go with the security alone. Meaning all those other official workers can't go with him. That is the holistic interpretation given to the policy. And by practice is what has been done. In fact, in 2019, the policy was even revised to include or any other spouse, a spouse or any other person. You know why? Because
it's for private travels,
for both. So it's for both. But in the case of private travel, then all of them who are not the family of the CJ, the spouse or the other person, plus just the security, because the CJ is an asset of the country. Even though you're private and Kabeka say you're quite intrusive, because I didn't make a holiday. Me minister told that please need me because I then I'll cry. Oh samisa baby I make be an samisa. But who hear more mining for that personal one the only official or just the security. That is the interpretation. That has been the practice and policy of the judicial service.
And for private one, the only personal policy security.
Yes, it's your spouse or any other person, but the other side you from clause 9 just the security. Because Kwame said, Kwame Sebi empomo kaya bia era ni ebo ane ne ko na sebi wo kohwe ne ho yare ani ade one ne yire kwenti kwame susu one person me come personal traveler me security pe ne nko na sebi bia yare mu ni bibi aho siesie bi mu bibi ba na enye me yi kunu ne ka me ho ana sebi obi o ye mabusuani ne kam na ye security man kwa na wo be so me sebi me be yare afefia na baby no na be paper na me two mu se ne asante for be ka ono pe na be hwesa ntwo we mu ne maka asema kwame it leads to absurdity enti mesre ya mo asem no ne kaneba ya yen kano na poso ne emfa emotions ne sebi me mpena semunti no emfa nka asem ye yesa na obia ni hwa ye say if you want to be loved sell ice cream obia ni hwa me say meten obia ne pema se wo ti hwa nye obia ne po asem onkra no mten nye obia ne po asem ye de sa me mpe we asem we de no ye mehi wo ye mi say e kasa ɛyɛ den a chief justice bi ɔbɛbɛ bi obi
penasem to obet me raise bibi e
government bi bɛba on pesa chief justice sa esa na ye twa to ho no ɛno na mesere
ma me reading this portion of the policy B, personal travel by the chief justice or say 1, the chief justice shall be entitled to 2 round trip business class tickets Accra London Accra into bracket to be utilized during his or her vacation. Travel expenses, hotel accommodation and per diem will be borne by the judicial service and capped at 14 days per round trip. 2, where the chief justice embarks on a personal or private foreign travel, he or she shall be accompanied by the security alone. 3, the travel expenses of the security comprising air ticket, hotel accommodation, and per diem shall be borne by the judicial service. Into a personal travel by the chief justice, and it still said the security alone.
Okay. Now, let me come back. Now, me say me ma for our travel, but I mean that's where we do it. First one, I'm the cancer by practice, law, and policy hasn't been breached. Secondly, the only determinator of whether there's been such an infraction is the Auditor General.
Sure.
Now, a simple inquiry.
Yes.
By some of us have even reviewed much more the Presidency and Council of State, who could easily have be armed with this information. There was an audit query
done
in respect of these travels, and which the Judicial Secretary then, Justice Pamela Cynthia,
they were resigning and saying,
made responses one after the other. One come. And yet travel in so asem and Auditor General raise other issues and fuel.
Yes.
Now so when him send Auditor General and Edumani City and all bad what raise no my response. The only one you no was back say me no one Judicial Secretary taking a time and responded one after the other to all the queries. The only thing that the Auditor General came back to respond to and said they did not agree and no they insist that they should pay was not even in relation to the Chief Justice.
It was in relation to
some other matters. Some fool will be that past CJs. And so they demanded that they be written to pay those monies, which they have done. In other words, the Auditor General received the response and satisfied with it. They satisfied only with aspects of FUA which was not related to the travel. Then came back and said, then this one I still don't agree. You have to pay, and it has been done. And that determinator of such an infraction of those travel policies is not you and I. It's not Daniel Ofori. It is the Auditor General.
But you are saying, sir, on the face of the policy, as I've read, say a private travel, now it was a security alone on the face of it. Now say on that private travel, no, ABR, the spouse of the Chief Justice, and now say that clearly breaches the policy.
No, on the face of it, you look at the law itself, the benefits he's entitled to, the practice as it is. Because this policy has been there decades, even before she even became Chief Justice.
Yes.
And a simple query would have indicated that that has been the law, that has been the practice, that has been the policy. In any case, his argument in the Crown Tunche, the final determinator for you to then establish that there's a prima facie case is not the petitioner, who even doesn't add any evidence, is the Auditor General. And that, for me, also at the government machinery, should have been as part of the considerations of the prima facie case, and has not been done. No problem.
No problem. There is this part of the response, and so I say Exhibit D04 is a response to audit observation provided by the Judicial Secretary to auditors who sought clarification on the expenditure, ticket purchase, blah, 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 during my 2 holidays in 2023. On page 1 of Exhibit D04, the Judicial Secretary clarified that as Chief Justice, I opted to utilize the authorization in paragraph 9 and paragraph 10 of the travel policy to travel with my spouse and my daughter during my 2 holidays taken in September 2023, pursuant to the conditions of appointment of the Chief Justice. There was no infraction occasioned when I opted to travel for my 2 holidays with my spouse on 1 occasion and my daughter on the 2nd occasion. The response to observation 1 and response to observation 2 of Exhibit D04 provide explanation on expenditure on ticket for my husband and daughter that petitioner has unfortunately described as misappropriation of public funds by the Chief Justice. And based on our response, we not just say the authorization policy in paragraph 9 and paragraph 10. Ena ono ye na just say obey you so ma cover ni kunu ene ne ba. That is again Chief Justice no exercise a discretion on a policy which is cast in stone. No.
Kwame.
Obi.
Enye sorry. Obi fache me. Obi.
No problem.
Enye srese. Emre bi e embi yenum because es wo mode even petition Emma Chief Justice.
Yes.
Responding yes oni hu kan say enti senko am ji samwe ya ka benya sa asema o kan eponi waka. Enye sere. Me build the case ama. Wo say maybe asem ye start by here no Vincent Asafo the court case say send Kodema Chief Justice and Chief Justice. Ye cast did atem twe kan ye mo. Senko amfa sa response we ama. Enti ka sa asem bi say ye nipa bi bisa wo de nkombenya wo hin de bisa. Says and committee dealing with Daniel for case. Then I feel you build the case on the response of a defendant, not on the strength of the case of the petitioner. The catch of the mechanism say, Samika someone was obese. Oh, response na masari gegitati. Response na CJ di mine and once a man amigusoka. It's my magic says, and no person says, as a me independent thinking, which I have. It's my young cousin, isn't it laughable now? That the very response that some of us have advocated for said the Chief Justice is entitled to receive and respond to it. Say no more we are hinging our argument on. Intiki am fighting. We are fast response now. Intika then and kind of be just what kind of work I actually.
Yeah, because there is also something called admission. In Tibia as a wow response.
But is they
admitted to new maybe.
But you see, the threshold is that you, the petitioner, must give us a sufficient basis.
Mm-hmm.
You must establish some strength, some modicum of justification for a prima facie case. Not based on the even assuming there is such weakness, on the weakness of the Chief Justice.
But again, because the argument say Chief Justice should respond, made the argument say to be able to do the prima facie determination, at least at that initial level, consider the Chief Justice's response. And when I get the response, I would make my prima facie based on the petition, the allegation in there, and the response. It may combine the two, then I can say, okay, where they based on response as CJ the buy, Still, I maintain and once papa or question was over the year, then I ground my prima facie based on that.
This was in the position of the president. The position of the president. In fact, also I tried their command because CJ Trouble.
Yes.
So we hear the language very carefully. Na echere say meni ho enye nhye say me de ma ma wohwem. Enti no ma trust restricted. Ebia ma trust no me de bro. Na say wo de ma obi a me ho. So de enye CJ na de ma ye ono na paafo. Ebi trogu ye Facebook so. Ebi kekan na de bibi ma me mamamfo phone so am ye nyina ye be hu bi. Make point and say the petition on the face of anyone else that you can't wasem should establish a prima facie case.
Sure.
Men person me ka no be ajimanu asiboni say I dan wo call news for sa ne response here the CJ response and aka. And I want us to have an objective analysis of what it is. And I'm saying that on the face of the petition, first of all, it does not attach the requisite seriousness threshold that is needed to establish a prima facie case, and should even be treated with the contempt from the onset without even giving a second look at it.
And this position on Some, and I say all the allegations.
All of them, because none of them did he even purport to even show some modicum.
No, make not the three.
No. Make us a Daniel for then. So I am got your track. Shining stars is one here. Almost one for here. The letter anybody. There's a modicum. Now Daniel for the said we will see in a book as a minimum as some tran as a maker and why enough. Which I think said the posture of it is inimical to the threshold under Article 146.
But you agree, so say, because I remember saying the case of Charlotte Osaedi, and when the petition was referred to the CJ then, in establishing prima facie, the CJ said some of the allegations were thrown out, but on some, she thinks there is a prima facie. Can that same argument be made today? Say 3 petitioners, or more raising different allegations. Some of them said, I mean, enough into another. But they are bakumi no be dear. There are some questions to answer.
Self to us, or man paying Sebi, and I self to any my. But the one lie, I found the Prima facie case and into my city committee. Sebi is trite and a general jurisprudential stance. So the quedu bo be now sequedu no menya Prima facie case, just a stanko case by quite free team says your munyanaka. Says all my reasons many panel will say in us won't tell me dear finding Prima facie case, Missy be you one no any yet dow court. Na yet then a pen muti say Chief Justice. Yes, one do deserve say a man who say in us wedding 5-day Prima facie case.
Be your committee now,
and not chow a po. Sa Prima I a Prima facie case I be a can was my other legislation case law me. And we can't see Yakasi young
him. That's true.
It will be.
That's true.
They are Chief Justice, yet mammy no office of the Chief Justice. A day. Yenija home. A pa a bar. Ye interfere with judicial. You see, I'll be a mere P make us a me. Someone says, "Who said that to me, Cassa?" So I went to you. Who said that to me? I have been consistent over a decade when it comes to judicial activism, when it comes to judicial independence, when it comes to security of tenure of judge. I was the first, one of the first, if not the first, to speak and write about the judicial independence and the need to take out what I call the bad nuts. Time I did Sani expose any kind. In fact, it was my first time I even went on a program like that. Again on Newsfile. That was my first appearance. And I've been consistent. Sebi, say Justice Asimesi, Anna Justice Asimesi, crown a Chief Justice, na and Sama Kukoya MY as a country, as a democratic country. Can you now, ye position I'm taking, can one miss Sebi Justice Palmer and one meteki, Miami Papa Justice Buff Body, say on one, and one messa take it. It's on principles, and then you say justice tokonu, Nenimu Yamefe, and now I say, and yes, our threshold, no, any area Article 146. I'm saying that there are other appropriate fora for addressing the grievances, if any. But not under Article 146, and there has been no basis whatsoever for establishing a Prima.
There are those who believe, the NDC in opposition made those points, say the judiciary should be reset. It was say some reset be also in the judiciary. With your years of practice, rising to become Deputy Attorney General, do you believe Sir statement? They say the judiciary we have now, it was a year who be kakra, and maybe I was a chance here from the top.
OBS who be saying, ye di who any a pobonia a whom here MY no a show a mumu and a hona menti. I said, hey, I make us say, and now say, by make a woman where didn't demo didn't say, say corruption is our baby, but that I see a fair simple chess. I judges know me, but don't paint all of them with the same brush. Resetting and only saying resetting no kasayemuna mati and they say if we say judges be MPP and on a michile umfiti as and say so what this argument in a bape let's say judge be a Ghana ewo party back because judge be from a magistrate a bear appointed to Ochena Supreme Court judge be a bear appointed be a president in Sawum a third MPP president. A toilet NDC presidency. It is here the sa kasaya no kwa ebe haye I didn't so beba. And it's a saying ye be listed judges who wants a time a Rollins time ye appointee being any NDC president at Tamil Sampacho when you baby con year Rollins or many maybe baby or me NDC for San Casayeno a home tea. And fam we biambre ye kebi mami kebobo emo edi drum kasia pa any collapse because who set us our precedent way to ope kwame mesre make maybe wo ya na wo kasa o se na NCC initially de bia me kase yes me busa office na nuntie o but kwame sa office no monye arm of government o empo mu kura to da mo ka mo say there's a fourth of arm of government which is the media mo mpo kura nko EC ho any NCC ho so what you say enti mesrew ni die ma de ani de wo na mo menche se bi judge bia ye bone na enu si say no but enye nyina so enu ana meka if he say sanitwa na say hu ne ba se ne meka ye no wo obi wo so ye lawyer ni ti se me a ebedu baby obegina court na wo ka legal staff wo de law wo na wa ye research judge nsi wonu otie wa obehe no ehu bi e de abon so won se yi na no yetimi yi chief justice said wo kwa de on ye ntontom kra nko wa yirem so what you say enti mesre so wo so be abuse human rights judge be abuse you can vindicate yourself hey almost ye yi o medi wo mu no ya transfer we say ye person ye chese president ne be ye in charge of transfers of officers for judicial service na ye see petition ti ye say president ne micromanage judicial service na busa lawyers or major judicial service. There are so many cases against judicial service. We need been well Lucy BBS and reinstate or money a day. Yeah, Obi made a message and the way chat if it's a mekoya eduma no sia. A big car case. We NDC ni lawyer, Okokota, near Buasam. Mesra kasasimi. Meaning say me near penny am respecting a partner or Obabomisa Macasasimi. But Obi. There were lawyer penny be a mi bunepa a friend lawyer kwaku osafo boabe.
Okay.
Me mitimi nene nyage nchese a lawyer penny or NDC ni. Court na her record ye won no any NDC for lawyer for bibira. One more when one case almost 90% every time. Ti said we want to mean so on your ma. And yes, I will catch re nenye. What did they make an say? And fan shall catch re. Lawyer kwaku osafo boabe. Pro NDC lawyer. Minutes now, Miss Brabkaku, case we udrine ho say, and nam ni dear, highly respected. Ain't sabi, and yet when I went to mean so on ya, my fan shall catch or fan shall catch it. Ain't it Kasana, a casatra any in Asubia. Ya will lawyers be what NDC more. I have so much respect for them. I even go to them to seek counsel. Sometimes even on case. In fact, a year maybe law suffer by me sending in case be a may me involved. I'm saying, penny way there's a case you mess over to me at me a quantity be. Follow his practice. You will find his success. In fact, order 81 or normal Supreme Court decided said there's a mistake in it. Now there should be all there. And any case or his advocacy, his intelligence, his par excellence, and even all judges at the Superior Courts recognize it. That is not the reason for this, what we are seeing right now. It is a deliberate, it is orchestrated, it is a ruse to interfere with the judiciary. And I ask every Ghanaian to be up in arms against what is going on.
But in terms of the conclusion, say orchestrated, no, the argument would be made, say, the president or no known member of the president administration an actual petition. I mean, President Ohana and Nsaka petition. Article 146 trying to process our own fan. As long as our process no according to what is in law, then those conclusions no will be very unfair.
I respectfully disagree. You see, aseme ba na eyo obi, and you can't disregard the previous statements that some high-ranking officers of the NDC, including no less a person than the president, even before he assumed the reins of power, and now targeted at the judiciary. That is frightening. And we only see a play out of that preconceived orchestration happening right before our eyes. And so it is not insulated. Sebi, ebia by providence ena omo kama ye tibie ma ye hu omo adwene mu ti putri mu pa e wo omo adwene mu a omo de ye de omo yi a play out na judicial justice no it emanates us from all the people of Ghana.
Yes.
And unti na messe say ye nyina ye nsori waka na ye nkase baby afi de afofo no modi afofo no e ho de entwa yie na ye mpene so na ebu ye nimtia say ye democracy.
My final question, GBA meet review media review na wo
me patch na me wo
ukobi
me patch na me wo news files one up and so share ya mentimi anko me no online because at the same time no na me kasa on the theme.
Okay.
Ewo conference na. Tina sa ama me ugina mfimfin ti me kasa we na me di meka na. If say na GBA for di kan as ma invitation ama magi atum.
Okay.
Na news file dey any bar later but me pese se bi adesua ye nyina ye sua free mu tina me decide say.
And I decide so the kasa. At the meeting mo pass a resolution.
As an individual member I can confirm that we passed a resolution to call on the revocation of the suspension. In looking at all the circumstances, don't forget it's a media conference was a conference of all the members of the association, which is the highest decision making with the General Assembly. And having now been privy to almost all the information after the earlier statement, which was made at the time that certain information had not come to the fore, and being the highest decision making body, we made that decision in the absence of the C under 296C and to ensure transparency and consistency with practice. These the suspension should be revoked pursuant to clause 11. Clause 11, which is there that the president may at any time
revoke
the suspension. And then yes, so that's what we call. So we did pass that resolution.
Yeah, but will it not just be because I know say you would inform the presidency about the resolution, but it will be just wait how much good people, so the president will not do anything about that.
I mean, it's not as simple as it is. In the coming events, we'll see, there are ways of dealing with this. It starts with a resolution, for instance, and there are other ways for addressing this issue. So I don't want to preempt and say anything here, but in the coming days, we will witness advocates of judicial independence fighting just for our freedom, fighting for that judicial independence and security of tenure.
By which time I may be a committee and start here in Juma.
Obi, phone so no.
My main kind message is Kakana Vienna or Quina Cocotua Juma. So, good day, Obi. I'm listening to our former Attorney General, and I like to respectfully offer a perspective. If she argues that the Council of State can err, which I agree, then shouldn't she also acknowledge the possibility of error in her own analysis and conclusions regarding the CJ suspension and allegations leveled against her by the petitioners? Let's allow the established procedures for removing a Chief Justice to run their course. If vindicated, she would be reinstated as the law dictates. And one of the questions are about the establishment of Prima facie and the setting up of the committee, just the initial things are a start. Nobody is guilty. The CJ would go before the committee when the lawyer any day. It is we are all running ahead of us.
No, Kwame. I'm sorry, Obi. Yes, I need a mistake. First of all, we open the floodgates like the Daniel Fury posture.
Yes.
Obi bet now about 100 judges or more be a region be a money and a petition. I don't have to add anything. And so my what you say. And no, is that precedent? And then the president will now be forming every committee. Let's not look at the economic side of it, the resources we expend to even call for meetings and all of that. We're not looking at the incidentals to it. It is a 100 a frivolous one because who say it's a and yet den cry. No one's all the pet obi our co school kakare the vessel is a crache. One for pen to paper so man, one true be mumma. No fingum na the fakoma president because you be finding we are not looking at the economic side even of things. You see, there has to be a threshold. In fact, even under criminal jurisprudence, there is a threshold for a statement. You make a submission of no case. You have to look at it because what is the point? Say you be wasting your time. I'll go into the case when there's no case to answer.
No case to answer.
Ain't it coming? You can't trust and you only say any who floodgates a open. Adia said will be at the Bibeba. Let's see a committee.
Yeah. And you interview us, I'm a cost where affidavit, let me change it. Now, Kwame coming there.
Fetch me over.
Yes. Excellent submission by Diana. It is deeply ironic that a member of the very committee established to remove the Chief Justice for alleged misconduct, including the misuse of public funds, is himself implicated in taking money allegedly from the Danish embassy in Accra while traveling on fully state-sponsored official duty. What happened to the maxim, he who seeks equity must come with clean hands? This entire process is politically motivated and nothing will save the Chief Justice. If I had my way, I would advise the NPP and other political parties to abandon their plans to demonstrate, as it would achieve nothing. President Mahama and his enablers simply want the Chief Justice out. Simpliciter. Samuel, Brian, Boabing, and Odiwe Abba. We say, Obi, where was the former AG when the MPP government used the same procedure to remove an independent constitutional body like the EC chair and her deputies? These same persons were supporting the same rules yesterday, but due to political interest, now they are speaking against the same rules today. Tell them the law is the law and nobody can change it. And President Mahama is respecting the law, so they should allow him to do his work and stop being hypocritical. Sir Prince, Ewo Ayen Suano, we say hi, Obi. Please. Okay, I'll say. Okay, that's from Mr. Okay, Jimmy Owusu Kwaten Ewo Virginia and on the way. But Jimmy, I'll come back to your message. Ma Menkanwe Obi. One thing you should let people know is that all proceedings at the Supreme Court are also recorded in the form of audio. So if you think the record of proceedings have been tampered with, why not apply for the audio recordings for that day's proceedings? Okay, that's some good information there. A bit to me, Abua and Komwa Yedino. Finally, Nafe Yema Honorable and Konkotwa Nejuma. So we say, Obi, I didn't know your full name is Kwame Yose. Anyway, ask lawyer if it's too late for her to take the issue to court, or the GBA does not allow its members to go to court on issues like these. If not, she should join us on the demonstration. Gastiman, Ewo Brekum. When I say MPP, any some parties say plan a demonstration. But you don't think, say, for a process like they say the medical fair trial, clearly know what happened. Demonstration to achieve what? No, but demonstration is a right that you exercise to express as part of the democratic dispensation your views. And you see, don't let's not discount the power of demonstration. Particularly, you see, the global world is watching. I've received countless correspondence globally, watching carefully, and the position of the GBA is the first start, and very soon you hear from it. It has implications, even on our international relations. Or implications in economy, even with dealings with investors. We invest in this country, because they say who are called to judge for us. You bet me you are more anyhow into all be investments. Crowd Ghana, none in home popo. No, new some are called to be an person who investors to trust in a system. They should also believe and trust that the system works. It wants a system governed by a constitution and you're putting in process. Why should anybody be worried? Indeed, the system works, and that is why we are asking that the system be made to work. I have stood here, Martina Hanama Kaise. Obi obeka say a process process na constitution is a process no. If you do anything with Article 2, which is contrary to the very provisions of the Constitution, it is null and void. It is unconstitutional. Today, the Nakasiyama processing because a process na issues Constitution so. And in fact, it is a responsibility of every Ghanaian, including you and I, to challenge any act of unconstitutionality. It's any see a chance and kokunu the entrance or the kind a tuni minimum we are now for your son mukwa. Near the Edibani Ayeno. I be betting me a Jessica free ni paninsum, saying young chama unko kwanza. Maybe I what and Miss so a tear from Fancher. Moose and Chen of Nikwami didn't cry interview. And you know now come on, Miss Obi, send me from Kwame, wife Fatcham. Where's over my regards to my dear sister Sonaba. I love the education she's given, and like always, she always says she's making women in leadership proud. I will only wish we could have these proceedings live for all to witness. Mami Efia Kuto and on the way. Yes. I mean, because I've heard others argue, said, as part of the constitutional review processes at Ekosiisen, maybe we should look at raising how to remove a CJ to be at par with president and speaker there.
That's why separate arms, independent of each other, and at par with each other. Let's not forget it, And some community, I see have a power on amendment. You see, another thing, I mean, person mix issues now. I'm here who say Article 146, I see a young baby. But some common is separate and distinct from what is happening now. The two conversations are not mutually exclusive. They can be had concurrently. But who can now they be friend and I'm sure say hey, as some kind ewo hosi and sisano wo. It's see I no cry kanumpo. Enyama.
Yes.
Obi mesro they say so sre me class for me coach me dey put down for me master say me later won no am my late nti e chopper no if you me dey fa so na akoma wo mo
mama na se na we dey nya okwan na to me eko hopefully you be sign so di nkomo bio we wish you very very well right
me da CPOB that's I mean come on
fantastic Ekosiisen is higher Sempa FM that was Diana Sunaba Dapa or a former deputy AG and minister for justice and Amotenenka